We begin with legal matters. The Supreme Court has reserved judgment in the suit filed by 16 states challenging the constitutionality of the laws establishing the Economic and Financial Crimes Commission (EFCC) and two others to a date to be communicated to the parties. At the resumed hearing on Tuesday, Imo, Bauchi and Osun states joined the suit as co-plaintiffs, while Anambra, Ebonyi and Adamawa states announced their decisions to withdraw their suits. Unanimously, the 7-member panel of the Supreme Court presiding over the matter granted their request and struck out their names from the suit, following the non-opposition from the Attorney General of the Federation and Minister of Justice Lateef Fagbemi to their withdrawal.
State to withdraw from this suit. The case for Nasarawa State is completely different from that which Kogi and other states are before the Supreme Court. Nasarawa State is happy with the establishment of the EFCC, ICPC and NFIU. But our own case is challenging the constitutionality of the directive issued by the NFIU, limiting cash withdrawal for states, knowing fully well that in Nasarawa State we have a social investment policy geared towards enhancing the living standard of the people at the grassroots, where His Excellency, the Governor Engineer Abdullahi A. Sule, out of his passion for lifting people out of poverty, initiated a program through which indigent people at the grassroots level are being shared some stipends, running into millions of naira, and is the talk of the state. And the entire people of the state are very happy with that. Now, by the time this policy comes on board to limit the cash withdrawal by the state, it will frustrate this program, and it by extension affects the living standard of the people at the grassroots. So this is why we are in court, not to challenge the constitutionality of the establishment of the EFCC, ICPC, NFIU. These are institutions that are in place to actually fight corruption that is bedeviling the development of this country. So Nasarawa State is still on its feet, seeking for the interpretation of the Supreme Court on the constitutionality or otherwise of that policy.
Meanwhile, the argument of the other states in their present suit is that the EFCC establishment law as enacted could not be applied to states that had not approved it under the provisions of the Nigerian Constitution. According to the plaintiffs, the provisions of the Constitution necessitates that the majority of the state's houses of assembly agree to incorporate the convention before passing the EFCC Act and others, which was allegedly never done. Hence, they argue that any institution formed under these laws should be regarded as illegal.